Well, let's start with the basis. The strangest thing is that if you read again the Universal Declaration of Human Rights, it's written in a way where every person has a right to all his or her rights. Like all human rights are presented with equal value in the Universal Declaration of Human Rights. Really, there are no hierarchical approach to human rights. Nothing in the Declaration states that a right would be more fundamental or less fundamental than any other right. Well, that was the spirit of the Universal Declaration of Human Rights. But for different reasons, and I'd say until the mid-90s, there has been this ideology, mostly among lawyers, I would say, that some rights are more fundamental than others, and that would be civil liberties, right to freedom of speech, freedom of association, and so on. So it's been a struggle. Although the two covenants, again, have equal legal value, they're not written exactly in the same terms, but the struggle had been for over half a century. Do social and economic rights really exist? Till the Vienna Conference on Human Rights, that's the well-known 1993 Vienna conference, where there's this one paragraph that is so naturally quoted these days that we don't even remember it's been a struggle at the time. And that paragraph states that all human rights are interdependent and that they're equal and interdependent, meaning that you cannot promote one human right without respecting, promoting, and protecting all other human rights, which puts back in the game, in a way, economic and social rights. I'd say, it's an open-ended concept. This idea of social and economic rights, you can see it as being over-specialized, like labor law would be seen as the specialization of the ILO, the International Labor Organizations, and so there's this tendency inside the UN to, this is for the guys up the hill at the ILO to take care of labor law. But economic, social, or you could say the same about UNESCO and right to education, or World Health Organization and right to health. So there has been this tendency to rely on the specializations of some agencies to promote, if not protect or guarantee, some economic, social rights. Since Vienna, though, social and economic rights are clearly back inside the UN machinery, if I may put it this way. And we have to thank the Committee on Economic, Social, Cultural Rights, which has been created after the adoption of the covenant of the same name. They've done a tremendous amount of work to present social and economic rights as strong as fundamental human rights. The wording of the guarantee is a bit different, though, because of the covenant on economic, social, cultural rights. Of course, every person has a right to, but they're written kind of in an open-fashioned way. It's progressive realization instead of it's not necessarily happening now. It may happen in the future, and so state parties has this tendency to say it's coming. We're doing our best. When you talk about the right to housing or education or health. So it still is a struggle, but since Vienna, human rights theory teach that all human rights are equal and equally interdependent in a way that their realization depend on the realization of all other human rights. So that's a state of the art. I would say this. I'm not a naive. I'm not saying that all state parties are, equally believing in the theory, but from a civil society perspective, and to a certain extent from a litigation perspective, we can now rely on the principle of interdependence. There is this one principle that cuts across the whole basket of human rights, which is equality and non-discrimination, which is a discussion inside the discussion, because at the domestic level, the understanding of what equality is or of what is the equal benefit of the law is not, exactly the same. So my question to myself was, how did we come from a more legal understanding of discrimination to nowadays where most discrimination issues are approached in terms of identifying vulnerable groups or talking about vulnerability. I think it has to do with the history of human rights code. So in a country like Canada, but it's not exclusive to Canada, we started in the 60s with a legal framework that basically was stating that, here's a list of prohibited grounds of discrimination, which was a political trade-off. What's on the list? It can be a more or less extended list. Of course, we didn't start in the 60s with sexual orientation as an example, wouldn't be seen at the time as a ground of discrimination, potential basis for discrimination. But the idea was not that people were vulnerable, it's more that they had personal attributes that could lead to exclusion or lead to prejudice or lead to discrimination. So you had a list of prohibited grounds of discrimination, and then a list of situations that couldn't be seen as acceptable. The time we wouldn't approach, it's more than a matter of vocabulary, I think. We wouldn't approach discrimination as being grounded in specific vulnerabilities or generating vulnerability. It was, because it was a lot about personal characteristics. You were a man, you were a woman, you were Caucasian or you were racialized, you were or not in a situation of handicap. But that was not something you could change. So the initial understanding of discrimination, I think, was fairly disconnected from the social environment or any contextual analysis of what discrimination was. It's a shortcut because if you think of the renting situation, of course, everybody understood that not everybody had equal access to the renting market, and that the renting market was excluding based on race or handicap or else. But still, it was strongly attached to immutable characteristic attached to a person. So, and we moved on. This was a very frustrating experience. I remember, litigating in the 70s based on human rights code. And what was the frustration was the output of that kind of litigation, which was either, damages, but nothing transformative. And what you would get from the court was not transformative. It was remedial, but not transformative. And you have to keep in mind that the 70s was the big decade of the war on poverty, namely in the United States, but it came to Canada to the Kroll report at the beginning of the 70s. So we introduced a new kind of political vocabulary, which was about social justice. The social justice agenda is strongly connected to a more in-depth and contextual understanding of what equality should be. Not that equality is that different from a non-discrimination objective or ideal, but it's a different process. It's an open-ended process. It's not a closed process or a more mechanical approach to the fight against discrimination, which is the basis of human rights code. There's been a lot written on that. What was the expectation of the Canadian civil society as we were negotiating the words and the substance of the Canadian Charter of Rights. And a lot of people who were at the time involved in the fight against poverty or fight for social justice in Canada, which was not very different than what was happening ideologically in the United States, would say that there was an expectation. And it's easy, it's quite documented that the expectation was that the venue of the Canadian Charter of Rights would contribute, would be a significant input to social justice, which by itself is not only a political, but a statement about our legal capacity to factor in or take in account the contextual analysis. So those were the 70s. So Section 15, the equality guarantee provided for by the Canadian Charter as example, 15 was strongly connected in a lot of people's mind to social justice, which would mean reaching for a more fair distribution of wealth, good, or correcting inequalities, exclusion. The reading of the word was different by the 70s. We knew that the rich were getting richer, and the racialized population were clearly systematically or systemically excluded from access to goods, employment, education, and so on. So the framework changed. And with that switch or that shift in the framework, moving from a mechanical or remedial approach to discrimination to a search for more social justice, came, I think, social science. Why? Because when we started litigating 15, this was something, we take it for granted nowadays, but at the time, you had to find the means and the experts to produce evidence that there was systemic or systematic exclusion, that the law was not equally benefiting to everybody. And then you would bring in, sociology, anthropology, qualitative research, that stuff, and transform that knowledge and expert knowledge acceptable to the courts. And this was quite a challenge. And we, the large Canadian we involved in social justice, strongly believe that 15 would help us provide more social justice based on this legal concept of a fundamental right to equal benefit of the law.